Well, from contract issues to income tax and estate planning, farmers and ranchers face numerous legal issues on a regular basis. Well, today, we're going to look at some recent cases involving farm bankruptcy and sovereign immunity. Roger McEowen with the Washburn School of Law is the man to do that for us. Roger, thank you so much for being here. So the first case that we're looking at right now, this involves farm bankruptcy in Kansas. What do producers need to know about this?
Yeah, this is an important case, Suzanne. Good to be with you. This was from Northwest Kansas, and what happened was, of course, the farmers got in over their heads. They filed for Chapter 12 bankruptcy, and they put a plan together that the court approved. They made payments on that plan for a year and then fell behind again and couldn't make the payments. And so they were requesting the court to give them an opportunity to modify that plan, which you can do. And our bankruptcy judges in Kansas, in particular, our Chapter 12 bankruptcy judges, are very pro-farmer, and they will usually bend over backwards to do what they can to help a struggling farmer put a plan together. And what happened in this instance was the court got to the point where we understand you need an additional loan, but what you're projecting in terms of your income and your expense, you're just not going to be able to pay that. So the court gave them 14 days to come up with a feasible plan, because this has to be feasible. That's a requirement in the bankruptcy code, or else they're going to get the case dismissed and they'll be collapsed probably into a Chapter 7.
So 14 days, is that a reasonable amount of time? Obviously, the courts, like you said, are always willing to help in a situation like this.
Yeah, that's pretty reasonable in this situation because the plan was already confirmed. They went a year into that and needed to modify it again. And so the court said, well, your projections are pretty rough here. We think you're going to struggle with this, but we'll give you 2 weeks to come up with a feasible plan that we think you can comply with. So we'll see what happens.
Well, Roger, our next case is focused on sovereign immunity and the Fair Credit Reporting Act. Tell us about this.
Yeah, this is a big deal because many people are probably familiar with the concept of sovereign immunity that says that you can't sue the big bad government for any damages they cause you. But there is an exception to that, and that is if the Congress in the statute at issue has specifically waived sovereign immunity against the federal government, then you can sue for damages. And this involved the Fair Credit Reporting Act. We had a borrower in this case that borrowed from USDA's Rural Development Housing Authority, paid the loan off in full by the middle of 2018, but USDA never reflected that on their books and kept telling consumer credit reporting companies that the loan was delinquent. Well, that causes harm when you get a bad credit score and you can't qualify for loans with favorable interest rates anymore because of this misinformation. The reporting companies told USDA of the problem. USDA still didn't correct the problem, and so the consumer sued. And the USDA said, well, you can't sue us. We're the federal government. We have sovereign immunity. And the court said, no, the way Congress worded the Fair Credit Reporting Act was to specifically waive sovereign immunity in these borrower situations. That is a really big deal, Suzanne, because about a third of all of the consumer loans out there are routed through the some government agency that goes through the Fair Credit Reporting Act. So that's a very important case, and it was a unanimous decision by the U.S. Supreme Court.
Wow. Thank you so much for breaking that down. Interesting to hear that. Roger McEowen with the Washburn School of Law, always a pleasure. Thank you for all the information.